All right, we are back at it today. We are going to be watching Natalie Cochran. This is day 8 of her trial. We were hoping yesterday that she would be taking the stand. It didn't happen. Ended up being a very long day. So for anybody who sat through and watched with me, I'm so sorry. You were probably as restless as I was, but should be happening today. They are just now getting live into the courtroom and starting. So we're going to go ahead and get this on. And let's hope today is the day. If she does take the stand, like I was saying yesterday, she'll probably be on the stand for 2 days. I think the prosecution is going to really go after her. So it's going to be an interesting couple days to watch of this.
Case of State of West Virginia versus Natalie P. Cochran. We continue in the trial. The case number is 23-F-343K. All parties are present, including the defendant, although we are missing Ms. Acord. Is she going to join us?
She will be joining us. She is at the office, but she's working on some stuff and she'll be here.
All right, thank you.
But I have her permission to go over the court's instructions on behalf of the prosecutor's office.
All right, thank you. I do have the individual submissions from the state and from the defense. I prepared a continuous charge to the jury that incorporates all of the submissions, both from the state and the defense, and sets it forth in the court's traditional charge. I suggest that maybe we could go through that page by page. Again, I've mixed up your offerings a little bit, but all of them should be included in the mix. So you have a copy there.
All right, since we're a couple minutes behind, I'm going to catch it up to where it should be at normal speed. Couple things to note right off the bat is yesterday Natalie's kids were sitting behind her, and so were seemingly her parents. No one is there right now. I don't know if they'll come in later or if maybe she asked them not to if she's taking the stand because it might be too emotional. I don't know.
And involuntary manslaughter. Voluntary manslaughter is not a consideration.
Right. I think we need to remove that. That somebody submitted that, and I guess it was either you or Mr. Victor.
No, I don't think we're there yet, Judge. I'm looking at page 8, and page 8 starts with murder of the first degree. And by the way, I don't know, this is a very, very minor thing, but I think we should be consistent with capitalizing certain things.
Okay. I think that's a big deal.
That's just,
Okay.
suggestion. But before, murder in the first degree is any felonious, willful, malicious, deliberate, unlawful. It has to be unpremeditated. The premeditation is the most important factor of the murder in the first degree. So it has to be there.
Okay.
And I don't know if we need to put the West Virginia Code section there for the jury.
All right, I'll remove that.
And then, of course, in that instruction, in the paragraph starting with before the defendant can be convicted of murder in the first degree, paragraph 4.
So this is good news, listening to them go over the different instructions for the jury. This kind of lets us know that she'll probably be taking the stand because they're getting all the paperwork ready to give them for after she's on the stand and for when they go back to deliberate. So as long as she is still planning on taking it, it should happen this morning, which is really what we've been waiting for. It's going to be very interesting. If you missed any of the other days, I'll just summarize really quickly that Natalie is currently serving an 11-year sentence for a Ponzi scheme. She ripped off millions of dollars from the public, but also family and friends. She was a pharmacist, had a really well-known reputation for being a good doctor. And little did anybody know that she was stealing a whole bunch of money from them. We don't know the exact details of how she went about it all, but we do know that her husband's parents were one of the top people that she was stealing from. Her husband, Michael Cochran, he is now deceased. He died of an insulin overdose, but he wasn't taking insulin. He has no medical history of needing insulin. And they think that he was catching on to her Ponzi scheme, which some people think he was involved in, but others think he was catching on, and she didn't want to be caught, and so she gave him an overdose of insulin and killed him. So that's why they're here. She's already in prison for 11 years, but they are now trying to see if she can be held accountable for his death as well. They have 2 kids together, a 17-year-old boy, a 20 or 21-year-old daughter. They were together for 19 years. So it is definitely an interesting trial after going through the whole Ponzi scheme, and now for them trying to tack this on. It'll be interesting watching her testify.
Because we've already talked about the definition of the first-degree murder. So now I think the next logical thing is to discuss the involuntary manslaughter, and then discuss the definitions of malice, and it's just about it.
Okay, where do you want to move that to now, Mr. Victor?
Before the top of page 9, before malice.
Okay,
Involuntary manslaughter is committed when a person caused the unintentional death of another person. Now, in in that paragraph, I think we have to modify this paragraph because, as Mr. Selden astutely noticed, this paragraph deals also with voluntary manslaughter, and we don't have any voluntary manslaughter anywhere. So I would propose the court instructs the jury that the absence of an intention to kill or to commit any unlawful act which might reasonably produce death or great bodily harm is either the main characteristic or the main feature of involuntary manslaughter.
okay, if you can write that down, you talk a lot faster than I can
Oh, I'm
write.
sorry, Your Honor.
That's okay.
I'm sorry.
I mean, I'll work it out the way you want it, but you'll need to write it down.
I think that the, okay, I have it.
Matthew. The main component.
The main component, okay.
Involuntary manslaughter. Take out distinguishing feature between.
Okay, main components. And then, Your Honor, we're arriving at the definition of malice. I've been doing some research on malice, and in the first paragraph on malice that is right now on page 9, the last full sentence, malice and intent can also be inferred from the defendant's intentional use of a deadly weapon under circumstances which doesn't give rise to legal excuse. I believe this may have been this may be one of those instructions that shifts the burden of proof to the defendant. Although I believe that there is the State versus Jenkins case, and it's probably all right, but
I think this is a pattern instruction.
Yeah.
I've seen it many times. I don't know where Mr. Truman dug it up, but maybe right out of a form book.
I think
It's just one of those stock instructions that the state keeps, and it's been offered as long as I can remember.
And that's
If
why-
it needs to be changed, then let's hear what
We
the
can,
basis
we
of
can
the
change
is.
it,
I think inference is all right, but then in the next sentence, implied, and once the jury starts,
okay.
Making
In
something
the next
as an
sentence where it
implication.
says it may be inferred or implied, what if we get rid of or implied?
yes. Um,
That's in there twice, so in the next sentence,
Okay.
get rid of it.
Right.
I see it up in the first paragraph too. Can we change implied to inferred?
Yes, Your Honor.
Okay,
Now, when we talk about involuntary manslaughter, I think that a full definition of involuntary manslaughter should be probably given, and that is, I will read it, and maybe I'll read it quickly, and then we'll try to parse it. A person is guilty of involuntary manslaughter when a result of the doing of an unlawful act in a reckless or grossly negligent manner, or the doing of a lawful act in a reckless or grossly negligent manner. He causes the death of another person.
okay.
Was that in an instruction the defense
That wasn't
submitted?
an
No,
instruction.
that's
Oh, you're adding this.
right. I think that would be the appropriate definition of involuntary manslaughter.
Well, do we have that in writing? Can you submit that?
I can write it in here and present it to you.
Okay. Does that sound all right with you, Mr. Truman?
Yeah, I'd like to see what it,
Okay.
Okay,
What it
let's
says
write-
before I comment on
Normally,
it.
there are written submissions that the court considers.
So for the involuntary manslaughter that he wants to make sure he's putting in there, her husband had collapsed. He hit his head on the counter. It was, I think, a granite countertop, and supposedly he chipped the granite with his head from how hard he hit it and fell. We haven't seen proof of that, but he then was laying on the ground, and she took pictures of him and was sending them to various people saying, oh, he fell and he won't get up. And evidently he didn't like going to the doctors. He didn't want to go to the hospital ever. He always said, don't do that. And so she let him lay on the floor. She called 2 construction workers into her house to help him be moved to the couch, even so he was completely not there. Like, he was out and not doing well at all. And I think it took her a total of 4 to 5 hours to finally take him to the hospital, and he died. So they're going to push for involuntary manslaughter and saying that she was following his wishes, but clearly things were really, really bad, and she did not try at all to help him. It's pretty upsetting.
raising the issue because it's not an element. I think it's been offered in every case since why it was decided. But it's there. I thought I'd raise the issue.
That's fine.
Can we just omit it?
We can remove it, sure.
Okay.
Now, on page 12, the first paragraph, that instruction is always questionable to me because this one, I believe, shifts the burden of proof to the defense. That you may...
Okay, I don't know that we need it. If we take this out, Mr. Truman, will it be a strong objection?
Vociferous, okay, go ahead and take it out.
Okay, I'm gonna remove it.
Although we do not accept the argument that it's just the burden. I don't think it does.
Well, I've put it in virtually every
I know.
every charge that I've given, but I don't know that we absolutely
That's
need it.
fine.
Okay.
And once, since I stand corrected about the defendant testifying or not testifying instruction, which is on page 12, I always insisted on the word must, and that is 1, 2, 3, 4, 5, 6. Seventh line in the first, well, in the paragraph that starts with, as a defendant is presumed innocent. It says that you should disregard it, no, not is, it,
Yeah.
and not discuss it.
Okay.
I think it should read you must entirely disregard.
Okay.
It because it's.
Any problems, Mr. Truman?
None.
You must entirely disregard it and not discuss it.
That's right.
How's that?
That's fine, Your Honor.
Anything else on page 12?
I think there might be in the next paragraph, second line. I think that wither is supposed to be weather.
Well, it was whether it just. Okay, I'll change wither to weather. How's that?
That sounds like a plan.
And I don't have any other objections to the end of the document.
Okay. Page 13.
No, Your Honor.
Any problems, Mr. Truman?
This is getting kind of repetitive.
I'm reading through the different comments, and it looks like she may have retracted this morning if she's testifying or not, which I will be so frustrated, but that might be what's happening right now. They're going over everything because she might be saying never mind, which will also be really interesting because the jury was told that she said she will testify. So for her to change her mind at the last second would be crazy.
Gender issue, second line.
Are we on 14?
Yes.
Second paragraph.
Second full paragraph. You have to believe that the defendant.
Oh, I see it. Okay. Change him to her.
Right. And then the last line, committed the crime. I don't think it's an of that you need there. That just needs to be deleted.
Run that by me again.
Yes, sir. The last line on page 14.
Yeah.
To establish the defendant committed the crime, I don't think of needs to be in there.
Right.
Oh. Got it. Okay. Page 15.
Nothing from the defendant.
Nothing from the state, Your Honor.
All right.
Okay.
I'm reading on their
16.
official website. So she has officially declined taking the stand. They are going over the jury instruction as we are watching right now, and the rebuttal testimony is expected to begin around 10. I wonder what the jury would have to be thinking, knowing that she had made the decision to take the stand and then just immediately ducking out right when it's supposed to happen. Let me know your thoughts, because I would definitely look at that as a bad thing. And a little bit disappointing. I wanted to hear some of her answers when it came to some of this stuff, like, for instance, him hitting his head and laying on the ground for that many hours and not doing anything to help him. Like, what was she thinking? Why didn't she call for help? Even if she felt like she shouldn't take him to the doctors because he didn't want that, why wouldn't you have somebody come to him and do something? But I guess we will not get to hear all of her answers. So while they're doing this, They're supposed to pick up rebuttal, like I said, at around 10 their time. So we're about 30 to 40 minutes out. I'm going to end this live. There was a trial that started yesterday that looked super interesting. I'm going to see if it's back up today, and I will make a live and hop over there. So if you're on and you were with me yesterday and last week for this, sorry that she had her change of heart last minute, because that's pretty disappointing. But we will find another